Okay, hi everyone. This is our first lecture, The Introduction of Law and Judicial Function. My lectures are not meant to be long and boring. I'm just really wanting to hit the highlights of each chapter, so make sure you're still reading the chapter and any of the resources that I posted as well. So this one is really just meant to be a refresher. A lot of this you have learned in your previous class, especially if you took my Introduction to Criminal Justice class at any time. So what is the purpose of the court system? Why are we studying the court system? Basically, why should we care? Those are all questions that you should be asking yourself this first week. The court system serves many purposes. Here are just a few of them. They settle disputes through the use of legal rules and principles. So this is where victims go for compensation after being injured or wronged in some way, or offenders are punished for breaking laws. Courts also make public policy decisions. This is where we get a lot of our social change on topics that the legislature wanted to avoid dealing with. So by making decisions in cases, we are actually getting our laws. Courts clarify the law by interpreting written statutes and applying general principles to specific situations. We'll look at that more in a little bit. So in this way, our courts are reactive. They don't just start on their own and come up and begin a case on their own. They have to wait for the cases to come to them. That's something important to remember. Another purpose of the court system, or another way of saying these same purposes, is adjudication. This is the most common function. It goes with the ones I just described above. This is the process defendants go through when they've been charged with crimes and then to decide whether they should be held accountable for their acts. That whole legal process that we know of is called adjudication. Another main purpose is oversight. This is the main purpose of appellate courts. They decide whether a lower courts abided by the proper procedures in making their decisions. So you might see those terms as well, also describing the other purposes that I stated earlier. So what are laws? In your previous courses, you should already have explored what laws are, have them been defined for you. But in case you need a refresher, laws are created by the legislative branch of our government to give citizens rules to follow. They are technically the written body of rules of conduct that apply to members of that society. It's how we maintain order, how disputes are resolved. So the purpose of the court system is to settle disputes or disagreements about those laws. Okay? And if you took my Introduction to Criminal Justice course, or probably any Introduction to Criminal Justice course, you know about the Code of Hammurabi well. Hopefully it's familiar to you by now. The Code of Hammurabi was known as the first legal rules to be written down or inscribed on pillars. I'll show you a picture in a moment. Rather than the laws that we see today, the code was more like a listing of judgments that would occur to solve a particular case. So this is where we get our eye for an eye concept. And the Code of Hammurabi is based on three basic beliefs: the belief in holding an individual responsible under the law, the belief in the sanctity of the oath of God, and belief in the necessity of written evidence in all legal issues. So this was the start of our written laws. And here's what they looked like. They were inscribed on these stone pillars, just in case you haven't seen them before. Some concepts that your first chapter takes a look at. Your chapter discusses the differences between two opposing views related to the development of laws: the consensus view and the conflict view, or theories. The consensus theory views people as basically good and just, and society as providing equal opportunities for most people. The theorists argue that societies are developed to maintain stability and make up a network of institutions that work to maintain social order, such as schools, churches, economies, family, government. Stability is maintained through cooperation and shared values, and they see conflict as temporary and can be settled through a neutral legal system. So that's consensus. On the other hand, conflict theorists see society as made up of groups with greatly different interests. There's a lot of dissent in society as people try to maximize their own interests. They view stability as temporary and as maintained through coercion, mostly that the more powerful groups exert their force over the less powerful. So you decide where we are on this continuum, and I can see it as a continuum. We're not one or the other. It's not black and white. There's some gray area in there. But think about where we fall on this consensus versus conflict theory of developing our laws. Here's some more concepts that I thought would be important to mention. When you think of the word justice, what comes to mind? Is that the same thing as a law? Your text says not necessarily. It is through law, though, that we can find justice. And I like this quote from your textbook, so I wrote it out here for you. Law is in accordance with justice when it respects, cultivates, and protects the dignity of even the lowliest person living under it. It violates justice when it does not. So something throughout this course to think about is, do you agree with that? How well does our society do that? And down at the bottom, I have the rule of law. What is that? Why do we say rule of law rather than the rule of men? And to put it simply, when we say we have a rule of law, we're saying that we have a fundamental set of values and principles in a society, and that these values and principles must be written down, and that we have a system and procedures in place to hold us to these values and principles. So it's those the written laws, the written values that we go by in society. We know what to do and what not to do, what's acceptable, what's not acceptable. That is the rule of law. Okay. Similar to this or linking with this is these two competing ideas of the core idea of our criminal justice system more in general. Now, you should already be familiar with these, the due process model versus the crime control model. 1968, Herbert Packard developed these two models to kind of describe the overall purpose and goals of the criminal justice system. I don't want to take too much time in going over them since you should know them already, but I wrote down the major differences for you here. And we can see how these models work within the court system and then within the courtroom in particular. So that's where it's going to come into play in this in this case, I mean. On the one side, you have the prosecutor who wants a defendant punished at all costs. So we see that more on the crime control side. On the other is a defense attorney who insists that his client has rights and procedures that need to be followed. That's more of the due process model. So we can also refer to these as presumption of guilt and presumption of innocence. Due process model, there's a presumption of innocence. There's innocent until proven guilty. There are procedures that you must go through in order to find somebody guilty or not guilty. On the opposite side, on the crime control model, there's that presumption of guilt, that they're guilty until proven innocent. We just need to put them away, move on, next. It's that assembly line kind of thinking. So in an ideal world, we want to balance these two models. We want efficiency, but we need reliability. So is that possible? As you read your text, kind of think of that this week. And now the last kind of area I want to look at is just hit on some of the main functions of the court system in general and bring up some terms that are going to come up for you throughout this course. Our laws are written very broadly. So when a case is brought in front of a judge, it's their job to find the right law, interpret it, and then apply it to that specific situation. So those decisions regarding the laws and how they're applied to the specific cases are then part of our history, and future courts rely on them as past decisions to make future decisions. This is called precedent. Okay? Judges rely on past decisions made by other judges to help them guide them on their current decisions with similar cases. So this is the concept behind the common law system that we have in place today. All lower courts are bound by decisions made by higher courts within their jurisdiction and use those past decisions as their guide. So if you hear precedent, That's what I'm referring to. One key point to remember related to precedent is that the decision is only binding to that jurisdiction. That is why we see different states have different laws and decide cases in different ways. So a decision made in the court system in California, where you live, is not going to be binding on a case that's decided where I live in Ohio and vice versa. It might be influential, the judges might look at decisions from other jurisdictions, but they only have to follow the past decisions if they're made in their own jurisdiction. Okay? A couple of other key terms related to the function of the court system. Stare decisis. You'll hear this brought up throughout the course. This literally means let the decision stand. If there is a past legal decision made on a specific legal issue that can apply to a current case, that past decision will be used to resolve the current case. It's kind of like saying we're not reinventing the wheel. If a past court in our area has already decided on a legal issue, then we're going to go with that same decision. So that's what stare decisis means. Let that decision stand. Judicial review. This will come up a few times throughout the course. I'm just giving you quick definitions right now. This gives the court system the power to examine laws and determine whether they're constitutional. This provides judges great power to interpret the laws and decide which ones are constitutional and which ones are not. An interesting fact is that judicial review was actually created by judges. It's not written in our Constitution. The case Marbury versus Madison in 1803 gave the U.S. Supreme Court the right to review acts of other branches of government. And this was a landmark case for that reason. Judges gave judges the power to interpret the Constitution and decide whether laws violated the Constitution. That's huge power. That's huge power. You can read more about the Marbury versus Madison case in your textbook, okay? And there's so much more to read in your textbook. Please make sure you are reading the chapters. Like I said, I don't intend my lectures to be long and boring and 40 minutes. I really just like to hit the main highlights to give you a place to start as some ideas and key concepts that might be coming up in quizzes and exams. And also, I think the most important concepts that you just need to know.